So, how do we determine whether an agency action is a regulation or not? Well, we have to turn to the government code in California and the California APA, the Administrative Procedure Act, that sets forth the process for the executive branch administrative agencies and departments to adopt regulations. And these formal actions can, like a bill, add, amend, or repeal. Of course, we're dealing with regulations and not statutes. All the regulations, 60,000 of them in the state of California, are found in the CCR, the California Code of Regulations, or the Code of California Regulations. As a threshold matter, you have to determine whether the proposed action by a state agency or body actually constitutes a regulation. If it is a regulation, then it's subject to the APA. If it is not a regulation, then it is not subject to the formal rulemaking requirements under the APA. So what exactly is a regulation under the APA? Government Code Section 11342.600 defines a regulation to mean every rule, regulation, order, or standard of general application, or the amendment, supplement, or revision of any rule, regulation, order, or standard adopted by any state agency to implement, interpret, or make specific the law enforced or administered by it, or to govern its procedure. So let's take a look at how the California courts have interpreted this term regulation and what sorts of actions taken by executive branch agencies and departments actually constitute a regulation under the APA. The first case is Savient Pharmaceuticals, Inc. versus the Department of Health Services, a 2007 California appellate court decision. And they said, the APA defines regulation very broadly to include every rule, regulation, order, or standard of general application adopted by any state agency to implement, interpret, or make specific the law enforced or administered by it, or to govern its procedure, except one that relates only to the internal management of the state agency. In Californians for Pesticide Reform versus the Department of Pesticide Regulation, a 2010 California appellate court decision in which the Supreme Court denied review, said to begin, in order to be deemed a regulation subject to the APA, an agency must intend its rule to apply generally rather than in a specific case. But the rule need not apply universally. The rule applies generally so long as it declares how a certain class of cases will be decided. In Morales versus California Department of Corrections and Rehabilitation, a 2008 California appellate court decision, the court said a rule applies generally so long as it declares how a certain class of cases will be decided. A regulation subject to the APA has two principal identifying characteristics. The first is that the agency must intend its rule to apply generally rather than in a specific case. And second, the rule must implement, interpret, or make specific the law enforced or administered by the agency or govern the agency's procedure. In County of Butte versus the California Emergency Medical Services Authority, a 2010 California appellate court decision, the appeals court said, if a policy or procedure falls within the APA's definition of a regulation, the promulgating agency must comply with the procedures for formalizing the regulation. This includes public notice and approval by the Office of Administrative Law, and a regulation that substantially fails to comply with these requirements may be judicially declared invalid. Now, what are some examples of regulatory action that did or did not constitute a regulation that's subject to the procedural requirements for rulemaking under the state's Administrative Procedure Act? The first case I look at is California Grocers Association versus the Department of Alcoholic Beverage Control Board, a 2013 California appellate court decision. And the appeals court said the regulatory action was a regulation subject to the APA because it was directed to the general class of retail off-sale liquor licensees that employed customer-operated checkout stands, and because its interpretation of the Business and Professions Code was not essentially rote, ministerial, or repetitive. Accordingly, the advisory was void. In Macy versus Superior Court, a 2012 California Appeals Court decision, the intermediate court said the clinical evaluator handbook and the standardized assessments protocol is a regulation within the meaning of Government Code Section 11342.600, even though it leaves up to an evaluator's independent professional judgment whether or not an individual meets the sexually violent predator criteria. A determination by the Office of Administrative Law that language in the protocol constitutes a regulation was entitled to deference. And then in Center for Biological Diversity versus the Department of Fish and Wildlife, a 2015 California Appeals Court decision, the appellate court said where the challenged policy goes beyond merely prioritizing or allocating internal resources and may significantly affect others outside the agency, such a policy goes beyond the agency's internal management and is subject to adoption as a regulation under the APA. And finally, in Delta Stewardship Council cases in 2020, dealing with, in the Court of Appeals, Appendix A of the Delta Plan that was adopted pursuant to the Sacramento-San Joaquin Delta Reform Act of 2009, the appeals court said that that did not constitute an unlawful regulation under the APA because it didn't fall within the definition of a regulation, given that it did not contain a written statement of policy that the Stewardship Council intended to apply generally. So the determination of what is or is not a regulation will decide whether the formal APA rulemaking process will have to be followed by the executive branch agency or department.